Brittany Woodman owed 3 separate medical debts to St. Rose Hospital, which were assigned to Medicredit, Inc. for collection. Woodman retained legal representation in April 2021 for her first 2 accounts and notified Medicredit of this representation. The third account was placed with Medicredit in June 2021, and there was a dispute over when Medicredit received notice of Woodman's representation for this account. Woodman alleged that she was contacted on 6 occasions, despite the defendant knowing she was represented by counsel, constituting harassment and unfair practices under the FDCPA. Additionally, she claimed that Medicredit used an automatic telephone dialing system, ATDS, to contact her without her consent in violation of the TCPA. The court granted summary judgment in favor of Medicredit, finding that the evidence did not reasonably support an inference that Medicredit had actual knowledge of Woodman's legal representation regarding the third account from June through August 2021. Therefore, the defendant was reasonable in its efforts to collect on the third account and entitled to summary judgment on those grounds. Woodman provided her phone number to St. Rose Hospital as part of a commercial transaction to seek medical care. Under the Federal Communications Commission's 1992 interpretation of the TCPA, consumers may give prior express consent for calls related to that transaction. The court found that Woodman's provision of her phone number constituted express consent to receive calls related to the medical debt, and Medicredit's actions were compliant with the FCC's interpretation of the TCPA. This case underscores the importance of establishing that a defendant qualifies as a debt collector under the FDCPA and a furnisher under the FCRA. It highlights the necessity for plaintiffs to provide specific factual allegations to support their claims, especially when asserting violations of consumer protection statutes. For non-financial institutions, such as educational entities, this case serves as a reminder that reporting credit information about students or employees can expose them to potential lawsuits under the FDCPA and FCRA. However, these institutions may seek early dismissal if they do not meet the statutory definitions of debt collector or furnisher under these laws. Feel free to call and speak to a Resolve Legal Plan attorney if you are facing debt collector harassment.